judgment in the matter of Crown against McCafferty.
Lord Legate will explain the Court's judgment.
This appeal raises an issue about the scope of the crime of causing a public nuisance. On 8 September 2022, the 6 defendants in this case took part in a protest outside a dairy works. The dairy works are owned and operated by an organisation called Müller UK and are located on an industrial estate near Droitwich. The whole estate is private land. The only road access to the various business premises within the estate is by a private road called Pointon Way. There is a sign on Pointon Way stating private land, CCTV is in operation, and no trespassing is permitted. As a result of earlier protests, Muller UK had placed temporary fencing panels made of metal mesh on Pointon Way in front of the main entrance to their premises. The defendants either chained themselves to this temporary fencing or sat down on the road in front of it and stuck themselves to the road surface with glue. They remained there for about 4 hours until they were removed by the police and arrested. During that time, no vehicles could enter or leave the premises. Those obstructed in this way included employees who had finished working on a night shift and were unable to drive home. The defendants were charged with an offence under Section 78 of the Police, Crime, Sentencing and Courts Act 2022. This statutory offence has replaced the old common law crime of public nuisance. The statutory offence can be committed in either of 2 ways. One way, the first limb, is by an act or omission which, quote, creates a risk of or causes serious harm to the public or a section of the public. The other way, the second limb, is by an act or omission which, quote, obstructs the public or a section of the public in the exercise or enjoyment of a right that may be exercised or enjoyed by the public at large. The defendants were charged with an offence under the second limb of Section 78. They pleaded not guilty and were sent to the Crown Court for trial. At the close of the prosecution case, the judge ruled that there was no case for them to answer. He accepted their argument that because Pointon Way is a private road leading to private premises, there was no evidence before the jury that the defendants had obstructed the exercise or enjoyment of, quote, a right that may be exercised or enjoyed by the public at large. On an appeal by the prosecution, the Court of Appeal, Criminal Division, allowed the appeal and made an order for the Crown Court proceedings to resume. The jury was discharged to enable the defendants to seek permission to appeal to the Supreme Court. The Court of Appeal certified that the proposed appeal raised a question of general public importance, and the Supreme Court gave permission to appeal. For the reasons given in the judgments which are being handed down today, the Court unanimously allows the appeal. I, Lord Legate, give the main judgment, with which Lord Reid, Lady Simler and Lord Doherty agree. Lord Sales gives a concurring judgment. There is a legal distinction, which is well understood, between a right of way, or other right to use land, and a mere licence or permission from the owner or occupier of the land to do so. There is no evidence to suggest that the public at large have been granted permission to use Pointon Way, let alone a right. Indeed, it is clear that they have not been given such permission from the sign displayed on Pointon Way, warning that the land is private land and that no trespassing is permitted. Only employees, customers, suppliers and others who are visiting the Müller Dairy Works or other business premises on the industrial estate for a reason connected with the business may lawfully use the road. That is so even if other use of the road is tolerated, in the sense that apart from displaying the sign, no active steps are taken to prevent it. Even if the general public had been granted permission to use Pointon Way, the language of the statute, in referring to a right that may be exercised or enjoyed by the public at large, is clear and would not reasonably be understood to include a licence or permission. The same conclusion is reached even if, as Lord Sales considers, the word right is ambiguous. It is an important principle that a person should not be subjected to a criminal penalty based on a doubtful interpretation of the law, especially where the penalty involves depriving the person of their liberty. Another reason why it would be wrong to interpret the word right as including a permission granted to the public at large is that this would require arbitrary and uncertain distinctions to be drawn between permissions granted to all members of the public and permissions granted to many or all but a few members of the public, and would make the question whether a criminal offence has been committed depend on the precise scope of the permission. The historical background to the offence also confirms the correct interpretation. Under the common law, there were two types of public nuisance. One type, enacted as the first limb of the statutory offence, comprised a wide range of conduct which was capable of causing hazard or annoyance to the public, for example by creating loud noises or noxious smells. The other type of public nuisance, enacted as the second limb of the statutory offence, comprised cases of obstructing passage along a highway or a navigable river. The essential characteristic of a highway at common law is that it is a way, following a defined route, over which all the king's subjects, or in modern terminology, the public at large, have a right to pass freely. A private way or other way not open to the public at large is not a highway. The statutory offence implements recommendations made by the Law Commission, and the Law Commission's report supports the view that the two limbs of the statutory offence are aimed at different mischiefs. The first limb is aimed at conduct which causes or has the potential to cause serious annoyance or other serious harm to a section of the public. The second limb is aimed at conduct which obstructs the exercise of a right that belongs to all members of the public, the paradigm case being the right of passage along a highway. The essential question raised by the appeal is whether there is a right enjoyed by all members of the public to pass to and from private business premises over a road which is a private way and not a highway. The short answer to the question is no, because what distinguishes a private way from a highway is that the public at large does not enjoy a right to use it. It follows that obstructing passage on such a road can only amount to an offence of public nuisance if the first limb of the offence is satisfied, and the defendant's conduct creates a risk of or causes serious harm to the public or a section of the public. That has not been alleged here, nor were the defendants charged, as they might have been, with an offence of aggravated trespass. The Court therefore allows the appeal and confirms the judge's ruling that there was no case to answer. The result of confirming that ruling is that the defendants are acquitted.